I'm just getting our YouTube feed up and then we'll get started. Okay. Let's get started. Mr. Getachew Smith, you there?
Yes, Judge. Good morning.
Excellent.
Oh, good afternoon.
Good afternoon. Ms. Rivers, are you ready?
Yes, Judge, I'm here.
Great. Well, we'll get started. This is case 19 SC. Oh. Yeah, it was set for 1:30. There's a one position calendar, Mr. Richmond. I just had to start late. I was over, as I mentioned, with Major English and his folks over in Assembly Hall. So we're up. We'll do this. I have to take a break at 2:40 if we're not done yet. And then we have Mr. Palmer, who I think you had to bring up and bring down. I apologize for that, but we'll do Mr. Palmer's plea after we do Mr. Richmond's hearing. Okay? All right. So we're going to get rolling. This is 19 SC 166510, State versus Jameek Richmond. And we are here today to talk about the defendant's motion to dismiss indictment for constitutional speedy trial violation. Mr. Franklin represents Mr. Richmond. He has filed an it's a 7-page motion with an attachment that includes Mr. Richmond's notice to the clerk of court when he was in federal prison that he was interested in moving forward with the case. We have Mr. Getachew Smith representing the state, and I think we're ready to go. Mr. Getachew Smith, anything we need to handle procedurally, or are you ready to go?
I'm ready to go, Your Honor.
Okay. Mr. Franklin, I will turn it over to you in a minute. I'll just let you know what I think we're working with, so you don't have to cover ground that I think I agree with you on. You'll have to establish it. But it sounds like the alleged incident was 5 years ago tomorrow. Mr. Richmond was arrested that day, so March 10th, 2016, in jail for a little less than a month, and has been on bond ever since. 3 years-ish pass until there is a true bill from a grand jury, this 19 SC indictment. And since then, obviously, there hasn't been a trial. There have been lots of things going on since then, but one of those things is not a trial. So I think we are squarely in the territory of presumptively prejudicial delay. Certainly, Mr. Getachew Smith will be able to argue against that if he thinks we're in a different posture. But I think we've cleared that first hurdle, which is the only reason why I'm reciting these facts. And so really what we ought to focus on are the 4 Barker v. Wingo criteria and how they weigh against the state or against the defendant. And you're free to say, Judge, that's all wrong. But if you agree with it, Mr. Franklin, I think you can dive into the factors.
Yes, Your Honor, I do agree with that. I did intend to call Mr. Richmond to offer some testimony. And of course, we'll go more so towards the 4th factor. And just to make sure, Mr. Getachew Smith, you can hear me okay, correct?
It's not all that clear. You sound very distant.
Is it better with my mask off?
I don't think it had anything to do with the mask. I think it just has to do with the audio. Yeah.
Yes, you need to speak up, Mr. Franklin.
Okay. Does this work better?
Much better.
Much better.
Okay.
You're making him stand up, but okay, he'll survive.
So I'm not sure if the court would prefer for me to kind of present my argument as it pertains to the first 3 factors of Barker v. Wingo.
Why don't we take care of the evidence,
Okay.
and then we'll do argument.
All right. We call Jameek Richmond to the stand.
All right, Mr. Richmond, if you come on up. And Deputy, we need you to swear the witness in. That's okay.
swear or affirm to the testimony you shall give to the court, the truth, the whole truth, and nothing but the truth, so help you God? Mercy. State and spell your name to the court, please.
Jameek Richmond, JAHMEEK RICHMOND.
You did it.
I did, thank you.
Okay. And Ms. Rivers and Mr. Gatachi Smith, that was okay from Mr. Richmond's end in terms
I
of
can hear
your,
Mr. Richmond quite well. And when you're at the mic, I can hear you well as well.
okay.
All right, we'll stick with the mics.
Okay, thank you.
Okay. So Judge, you've kind of spoken to this, but I just want to begin the line of questioning here. Mr. Richmond, you were arrested for the rape allegations in March of 2016, correct?
That's correct.
Prior to that date of arrest, how did you make your living?
Photography, working with event photography.
Okay. Did you have your own company, or did you freelance or work for somebody
I do
else?
Freelance jobs with particular companies and events, like event companies and venues. So I was working with Premier Event.
Premier.
Entertainment. Yeah, Premier Event Entertainment.
Okay.
That was one of my main
When you say events, what kind of events are we talking about?
weddings, birthday parties,
Let me clarify.
nightclub events.
Premier Events is the name of the company you're
Name of the
working with.
company.
Right, but the type of event you'd be doing photography at would be a wedding, a birthday party, whatever.
Absolutely.
Okay.
Absolutely.
Okay. Were you an employee of Premier Events, or what was that relationship?
More like a subcontractor.
Okay.
They are the DJ and service the lighting and all the rest of it. And I would come in with the production, the
Okay, so
video.
So you were kind of part of the package of what
Yes.
someone would hire for. Okay. Now I think you said that was your main part of your work.
Yes.
Okay. How long had you been working with Premier?
About 6 years.
Okay.
6 years prior to 6
Okay.
years.
Could you offer an estimate as to how many jobs you had done with them?
Over 80 jobs.
Okay.
Over 80 jobs.
Was it a full-time gig, or, I mean, I guess it wouldn't, there's not a wedding every day. You would do events when they had them. What else was paying bills for you?
Well, I would get my own, small projects. I would get pickup jobs.
Okay,
Other little photography.
not through Premiere. It's just folks would know you and they'd say, Mr. Richmond, could you come take pictures of this event?
Yes, here and there.
Okay.
Yes, sir.
Do you feel comfortable offering a guesstimate as to how much of your income would have come from Premiere versus jobs you were able to get on your own?
Excuse me, sorry about that. Most of my income.
Okay. So you were arrested in March of 2016 for these allegations that we are kind of discussing today. How long were you in jail?
I did a year. I did a month, under a month. You're talking about the initial,
Yeah, when you were first arrested on these rape allegations.
almost
You were-
30 days, a little under a month, I believe.
Around a month?
Yes.
Okay. And how did you get out? What?
I bonded out.
Okay.
I had a paid attorney and just represented me for the bond, only for the bond hearing. So after that, I was used a public defender following that.
Okay.
Of course, you know.
So when you say use the public defender after that, are you talking immediately, like in April when you were released, or is that sometime down the
But
road?
once I bonded out, I guess apparently one was assigned to me. For
Okay.
that.
Okay. Did you attempt to try to hire anyone else for your case?
I actually did.
What were
I
those
went and did some
conversations like?
quotes, and it was 20,000, northern of 20,000, and these kind of things. And I really didn't have it. Like I didn't have it. It was
Okay.
It was
So-
kind of hard for me.
So you had been assigned a public defender. Had you had any contact with that public defender?
No, I actually never even spoken with the public defender.
Okay. Back in 2016.
In 16, correct,
Okay.
initially.
And so you were interviewing private attorneys to see how much
To
they would
possibly
cost.
acquire and get help. Yes.
And did you have the money to hire private at that point in time?
No, I did
Okay.
not.
So when you were released, were you able to continue working with Premier Events?
No.
Okay.
Why?
They said because of my background.
So you either had to tell them or they could run a criminal history check. How did they know you had gotten in trouble?
Because because I just can't, I was gone. I was missing.
Okay, you're gone for a month.
Yeah, so what happened? Got into a little trouble. This is someone that I also knew outside of working with. So he honestly pulled me to the side and said, Ja, we did the background and it's pending. However, we have some celebrity clients. We have some clients that, who require that. And I was unable to work with them thereafter.
So they informed you they had clients of a different tier, and they required background checks for those particular events. And
Yes,
Premier was able to.
Correct.
Okay. Premier was able to confirm that you had an open case for rape allegations.
Yes,
Okay.
sir.
So you later found yourself in some other trouble. Could you tell us about that?
Well, I ended up getting involved with some credit card stuff, trying to hustle the money up, which ended up with the federal case, which was the credit card fraud stuff and the credit card stuff.
Okay, so let's fill in the blanks. We kind of jumped a little bit. So you stated that you got in trouble for some credit card stuff.
Yes.
Where was that?
It was in Tennessee.
Okay, and what year was that?
That was later in 16.
Later in 16. Had you been involved in this credit card fraud related stuff?
No. It was a kind of like felt like my back was to the wall, and some people who they just said, "Hey," and I said, "Well, I'm in a tight spot, and I didn't think it was, so I was just thought I was hustling. I just thought I was hustling."
For clarification purposes, you said you felt like your back was against the wall. What do you mean by that?
It was kind of like a dark area, like an anxiety, I felt the anxiety come over me of this stigma, and I had to try to protect myself.
Okay.
What was the Tennessee connection? Had you lived there before, or why'd you
No.
end up there?
The case went federal because we traveled from Georgia to Tennessee.
Okay.
So that's the reason how it went.
Cross state lines.
Yes, sir.
Yeah.
Yes, Your Honor.
Okay.
So you stated that the case went federal. Was it always a federal case?
No. It began in the state, which was, I guess, it wasn't completely closed, but I guess after my attorney informed me that it was done in the state, but the feds may pick it up. So
it was done in the state of Tennessee?
Yes.
Was it dismissed, or did you plead to that case, or what happened?
Oh yeah, I plead to the guilty. I plead to the guilty.
So you pled to the fraud related charges in Tennessee.
And in exchange, I guess it just was no longer in the state, I guess, or just on hold or on ice or whatever.
Okay.
Until I guess the feds picked it up after the indictment.
Okay, so you end up dealing with the federal courts.
Federal courts.
Related to the same
charges in the feds.
Okay.
In Tennessee or in Georgia?
Well, in Tennessee.
Okay. Now you may mention that it eventually went federal. Tell me about what the federal case and involvement was like.
Well, it was just me just wanting to hustle and feeling like I said, my back was to the wall, wanting to.
Well, let me ask this again. So we talked about kind of what led you to doing that. When you got the federal case, did you go to trial on that case? Did you plead to that case?
Yeah, I was sentenced to 20, I was sentenced to 20 months. 24 months, do 20 months. During that time, that's when I reached out to the courts. During that time for this case.
Okay, so let's talk about that. So when did you start your 20? When were you arrested federally?
January 2018. January 6, 2018, in fact.
Okay.
I was arrested just driving with a friend, unknowingly that I had this warrant out. Because the
federal warrant?
Federal warrant.
Okay.
Unknowingly, I had a warrant out and was just riding with a friend casually. He had a new car, paper tag, was pulled over. And I was a fugitive of justice, which.
Where were you when you got pulled over? Georgia or Tennessee?
Georgia.
Okay.
It was Georgia. I'm around 400 South coming down.
I don't mean specifically, but
Sorry. All right.
The only connection you've got to Tennessee is that's where some of this criminal stuff happened,
Right. That
the
was-
fraud stuff. Okay.
Okay. Now, you say you were arrested. This happened in January of 18.
Yes, sir.
Okay. And you were in custody until when? Federal custody until when?
I was in federal custody for the entire 20 months. I served my 20 months.
When were you released?
I was released in that night, September 2019. September
Okay.
27th. Excuse me, September 29th, 2019.
Okay. Now,
I
you,
was also sentenced to a year probation.
okay. Now, you made mention that while you were in custody, you reached out to the courts. What courts are you referring to?
Fulton County courts, these courts.
Okay. Why did you reach out to Fulton County courts?
Well, they were offering some rehab services that I would.
Okay. And let's try to use pronouns. You say they were offering
I'm
rehab
sorry,
services.
The federal rehab,
The prison
the
system.
prison system, they were offering some programs that I would rather take advantage of, not only to help myself but to help my time. And I was unable to participate in these programs.
Okay.
So this is the reason why, after looking at my record, this has always been something over me, but it was also preventing me not only from what was preventing me from before in the world, but also even incarcerated. And so I just reached out to try to help myself in the situation, get some rehab.
Okay. So you reached out to the courts. Did you eventually make contact with an attorney regarding that? Did you
Prior to you? No. I mean,
Okay.
I had problems. I spoke with the head of I think she's the supervisor over at the the PD office.
Okay.
Spoke with the supervisor there. I was informed, a few different things, and had to continue to follow up to even get the assistance. And
Okay. At any point in time, you learned you were indicted. Did you learn you were indicted?
thereafter, after I wrote the letter, weeks later, that's when I was indicted. After I
Okay.
reached out to the courts.
Okay. While you were in custody and after you had learned you had been indicted, did you make any efforts to reach out to an attorney or figure out who your attorney would be?
Oh, absolutely. I with my continued efforts, I continued to call the PD office and was informed that it's been switched and a lot of changes have been made. And so I just had to continue to
Okay.
follow
Did you
up.
eventually find an attorney?
Yes,
Okay.
yes,
And if I may lead just a little bit, you and I eventually spoke, correct?
absolutely. Yes.
Okay.
You and I spoke.
But when you say find an attorney, meaning you were trying to figure out who from the public defender's office represented you? Or
Yes.
do you mean you were out there trying to hire someone?
Well, while I was incarcerated, I was trying to see who was actually on my current case, Your Honor.
Okay.
Yes, sir.
And it looks like you got indicted, I'm looking at your case file, in April of 2019. You still would have been in BOP custody.
I was, in fact.
Okay.
I was, in fact. Yes, sir. Your Honor, excuse me.
Okay. Now I want to fast forward a bit to when you were released from federal custody. You said that was towards the end of September.
Correct. 27.
Okay. Where were you released to?
I was released to New York to do my 1 year probation.
Okay. And
Why New York?
Well, that was with my mother.
Okay. They didn't say you have to go to New York. You said, when I'm released, I want to be in New York. And that's where you did your supervision.
They approved a post to my child's mother while I was living before. They approved my mother's home rather. I guess they determined it'll be more of a better fit.
Okay.
Okay. And let me ask this question. Prior to the allegations, the rape allegations, where were you residing?
In Georgia,
Okay. What was your address?
1314 Piedmont Avenue, right across from Botanical Gardens.
Okay.
Across from what?
Botanical Gardens.
Okay.
Piedmont Gardens.
Okay. And what kind of, did you own an apartment? Did you own a house?
It was
What
a room. It was a rooming house. It was a rooming house.
Okay. Did you have your when you say a rooming house, did you have an entire unit? Did you have a kitchen and bathroom, or what
No,
was that like?
it was a rooming house, three level rooming house, one bathroom on each floor, about about 6 rooms on each floor, very close, kind of close quarters, and but it was a space, comfortable enough space to, convenient in the city, and
Okay. So I guess what I'm trying to be clear on, so it's like your room, and is everything else kind of a common area, or?
No, there's really no common areas, honestly. In that particular house, it was just rooms in that house.
Just rooms, okay.
In this house.
And so you literally just had your one room, and if you needed to use the bathroom, you would have
Had
to
to
leave
go
your unit.
out, leave the room, and even there was no refrigerator in that house, which is kind of weird. But because all 3 houses were rooming houses, and just go next door to use that fridge. But anyway,
So it kind of sounds like a college dorm kind of situation. Is that fair?
yes, you could say that.
Okay. Okay. Did you rent from a company? Did you rent from a particular person?
Now, I rented from a particular person.
Okay. What was his
His
name?
name was Greg.
Greg?
Not sure his last name. It's Greg. His first is Greg.
Okay. At any point in time after you were released from federal custody in September of 2019, did you return to the address on Piedmont Avenue? Did you try to go there?
Yes. Actually, last summer, I revisited it last summer, June. I would say June. I revisited Piedmont, 1340 Piedmont. I seen Greg.
And what were you going back there to try to do?
Well, I was going back to ask him about if there's any camera footage or anything or any of the people who currently were living there at the time, are still around. And he informed me that there's an old man, he died.
I'm sorry, you said there was an old man.
Yeah,
who
it was
died.
an old man in the bed, he died. It was just some people who were, it was like a community, a small community.
What was the old man's name?
Did are we asking about this because whatever is alleged supposedly happened at the rooming house?
Yes, all right in front of it. We all was outside. And that's my on the left side in the front window on the left. That's my room. Oh, sorry about
Google
that.
Map. I used to live right near there, so I was just trying to figure out where the house was.
I said,
Yeah, it's all
I haven't
tore
seen the
down
picture.
now. It's all tore down, but on the left side is where my room, right in the front on the left side.
Okay, we don't need to get into
Sorry
that. But
about
the
that.
reason why you were interested in going back to that address is that the allegation was you did whatever you did at your place.
Yes.
And so camera footage would be interesting.
Yes.
Okay.
Also, the young woman who's made the allegations against you, has she had any interactions with the other persons who lived in the home, in the rooming house?
Thereafter, I don't.
I mean,
On that day, yeah, we was all out there, just having a couple of drinks, little smoking a bit. Just everyone was kind of collectively hanging out.
okay. So yourself, the young woman, who else would have been hanging around to kind of see how you all were interacting?
Got Terrence. Well, not T, but Terrence. Got Kim. What is his name? My Russian friend Alex, and the old guy, I forget his Chris.
Okay.
But he's
Okay.
passed now.
Were any of these people that you just named still at this rooming house when you were able to return?
No.
Okay.
No.
Was anybody at the rooming house when you returned?
No, it's completely cleared out. They were deconstruct. They were tearing it down. They started. They was getting ready to tear it down.
Okay. Is that building still standing today?
No, it's gone now. It's gone now. They have some condos coming up.
I'm sorry, they have some what coming up?
Some condos or
Okay.
some sort of.
Okay. Since you have been out and living in New York, have you been working?
Not solely, just pickups and no.
Okay.
No.
You said not solely. Are you
Nothing.
You said you're a photographer.
Yes.
Okay. Have you had any jobs since you?
They're like very small pickups here and there's, if I can, honestly.
Okay.
So
But
you
I've
stayed in New York at your mom's address since you were released from BOP custody?
Yes, Your Honor.
So the address that's in the system for you in Brooklyn, that's your mom's place, and that's where you've been?
Your Honor.
Okay.
The 1064 address. It should be.
Yeah, 54th Street?
Yes.
Okay.
Your Honor.
Where was I?
Well, let me pick up where you were, which was employment. I hear you that maybe you haven't been doing photography. You're trying to help with your mom's bills, et cetera. That's not the only thing you can do. Did you try, were you a Uber guy? Did you try to go to medical school or?
So what I did was I was applying for jobs and I kept getting this background check kicking me. So it was kind of like, it started to kind of, weigh me down a little bit in a way of putting me in just a mind frame of what to do in a way, kind of getting a little anxious. My mom needs, I have 2 kids, my sister's in college now. And it kind of just put me in the spot of, okay, what to do to provide for my family. And
Where are your kids?
I have one here in Georgia, she's 12, Peyton, and Alani, she'll be 14. Wow, she'll be 14.
Where?
In New York, in Queens, with her mother as well. So.
Okay. Prior to these allegations, were you able to provide some financial support to the mothers of your children?
Absolutely, yes, absolutely.
Okay. Since you've been released from federal custody, have you been able to provide the same kind of support?
No, sir.
Okay. Have you tried to get jobs outside of photography?
Absolutely.
Okay.
I've applied to a little bit of everything, but I always get the same kind of kickback. Furniture, from everything from furniture stores to Amazon, and
Okay.
I mean, I'm just, next thing is like fast food or something, I guess, right? I mean.
Okay. How do you know that the reason you weren't able to get jobs with the furniture store, Amazon, is because of this case and not the federal stuff that you did?
I will get on a background check. It'll say it reads it off specifically.
Okay.
But do the would-be employers say, Mr. Richmond, you look great until we see your background? Or are you just assuming that they said no, as opposed to you had a bad interview or they need someone who's left-handed and you're right-handed?
Absolutely. I wouldn't say that I'm the greatest, interviewer or even, but I do have a pretty extensive resume. I'm pretty apt to understanding and learning. So when I do interview, it goes good. Not to say there's not someone else better, but to say for the majority of the time and the percentage, it's like, okay, all we need to do is get the background check in and you're good.
Okay. And then they get the background check in.
You're not good.
You're not good.
And I was setting those up to lay a foundation.
Okay.
That's another question. Would you receive communications from those companies about the nature of your background?
Yes, sir.
And you receive those in email?
Yes, sir.
If I were to show you an email that speaks to this, would you be able to read it and tell me if it is related to the job that you've just talked about?
Absolutely.
Okay. So I don't know how to handle this right here, Your Honor. I wasn't, prepared for Mr. Gachachu Smith to not be in court. I have 2 exhibits, defense 1 and 2. He's not yet seen these. But
Why don't you just describe what they are? And we're in a sort of like, it's an evidentiary hearing. There's no jury here. So I think I can mediate this. And if
And I can
they
also-
shouldn't come in, they shouldn't come in.
Yeah. So the first, defense 1, is an email from payroll at Surplus Furniture. It's addressed to Mr. Jameek Richmond at yahoo.com. The title of the email is Post Adverse Action Notice, Express Furniture Warehouse. And it is a letter saying that.
Well, don't go into the contents of
Okay.
it, but so you describe what it is. And in particular, it's the way Mr. Richmond might be able to verify it or authenticate it is an email purportedly to him.
Correct.
Okay, what's the other one?
The other is a similar email. It states urgent adverse action notification regarding your consumer report for Amazon Salesforce. And it says from accurate background at no reply at accurate.com. addressed to jameekrichmond@yahoo.com. This one is sent June 23rd of 2020. The other one had been sent February 27th of 2020. The first one.
Mr. Getachew Smith, I know you can't see these right now, but you've heard the description. They sound, Mr. Richmond needs a chance to look at them, like they are authenticatable, if that's a word. And they certainly sound relevant to this area that Mr. Franklin is exploring with his client. Do you have any objection to them based on what little you've got? I'll make sure you can get your hands on them. And if you feel like they should not be made part of the record and that I should not consider them before I reach my finding, you will not have waived anything at this point.
Your Honor, I have no objection at this point.
Okay.
All right. Thank you, Mr. Smith.
Mhm.
May I approach, Your Honor?
Yes.
I'm approaching first with Defendant's Exhibit 1. And take a quick look at that, Mr. Richmond. And let me know if you recognize that.
Yes, this is the. It's one of those.
Is this the furniture one or Amazon?
This one is the furniture store.
Okay.
This is one of those.
This is an accurate representation of the email that you received regarding your employability with the warehouse, the furniture store.
That's correct.
Okay. Your Honor, subject to Mr. Getachew Smith's review, we would like to tender this in evidence.
Okay. I'll admit one, and in the future, just give them both so you don't have to go back and forth.
Because of the odd stuff, I don't want to confuse this one.
Okay. But I'll admit defense one, Mr. Getachew Smith, we'll make sure you get a copy of that. And if you review it and want to make an objection, it will be deemed timely. And if I need to pull it out of the record, I will do that.
That sounds good, Your Honor.
I've handed to you Defendant's Exhibit 2, Mr. Richmond, a single piece of paper. What is that?
This is also another one of those background checks that includes rape and all the charges alleged here, and it's the background check saying that you did not make. I'm not in. I can't go. That's not.
Okay. Your Honor, I'd like to tender into evidence Defendant's Exhibit 2.
Same ruling. It's admitted subject to Mr. Getachew Smith's post-hearing review. And he can shoot us an email saying he continues to have no objection or he does have an objection.
Thank you. Mr. Richmond, we had some discussion about the difference in your ability to provide financially for your daughters, both in New York and here in Atlanta. What is your parenting arrangement with your daughter in New York? What is that like?
With my daughter in New York, her mom has a full-time job, so she sleeps at her mother's house, but she's with myself and my mother majority of the time to do homework and remote schooling and things.
Okay, so you're able to have a relationship with your daughter who's in New York, correct?
Absolutely.
Now, you have a daughter here in Atlanta as well, you stated, right?
Yes.
And that's Peyton.
Peyton.
Now, who has custody of Peyton?
Well, currently her grandparents have custody.
Where is Peyton's mother?
Her mother is in Stone Mountain.
Okay.
She's also here.
To your understanding, why does Peyton not live with her birth mother and instead lives with her grandparents?
Her mom suffers with some mental illness. So I'm the only sane. I'm not gonna say only sane. I'm gonna say I'm the only sane mind in the household, in a sense. So she's with her grandparents for that reason.
Okay. Do her grandparents is she just staying with her grandparents?
They have legal guardianship right now.
Okay, so they have guardianship as established through the courts?
Through the courts, yes.
Okay. Have you attempted to try to get custody or
I haven't, because I know I have these pending charges. To be honest with you, I have the people in line to do it, but I know because once I present myself to the courts without the means, you need the means. You have to provide stable living. You have to provide, they're looking at your background. There's factors that I've accounted for, and my daughter's not in the worst position, but I know we have to do better. I have to do better for her, and I can't do that because
Your pending case.
my pendant, yeah, when I go and do this, they're gonna ask for that.
Okay. What is your day-to-day like in terms of, it's great that you're out on bond and able to have some freedoms, but how would you describe your mental state waiting this amount of time to learn about to deal with your case? As the judge says, it'll be 5 years tomorrow.
Right. Naturally, I'm an extroverted person, I feel like. But with all of this happening, over the time with the weighing down and the unknown and me, just the accusation over me and the stigma, and it just puts me in a dark place of like the unknown. Not only that, I'm trying to figure out how to provide for my kids, myself, and like just the anxiety, even social anxiety when I get out in front of people. I'm a photographer. And when sometimes I have to force myself to even, and it's most times I can't do it. I have to choose a day. I have to choose a time. I have to choose a time just to do this, because it's caused me to go inside myself. Like people are looking at me, and although I know people are looking at me, and I just feel like they look at me and see that. They look at me and say that, even though they don't know me or what have you, but it weighs. And I come with nothing but positivity and great intent and great what I do a lot for people, so, and it really put me in a space, and I stay positive. I still remain positive, but it put me in a dark spot mentally.
Okay. The only other thing I have, Your Honor, and I attached it to my initial motion, is a copy of the letter. Do I need to
I don't
introduce that
think
in
you need
evidence
to,
as part of the
because I
motion?
think it's actually part of the official record already.
Yeah, it is.
Let me confirm. I was in there, then I wanted to look at the address. Yeah, Mr. Richmond's December 7th, I mean, he wrote a little earlier, it took a minute to get to the clerk's office, is part of the docket. It's dated December 3rd, 2018. He wants to resolve his pending charge, and he puts the CP number in it.
Okay. At this time, we have no further questions. We turn the witness over for cross-examination.
Okay. Mr. Gatacho Smith, do you have questions for Mr. Richmond?
Only a few, Your Honor.
Okay.
All right. Good morning, afternoon, Mr. Richmond. I have a few questions for you. First is, did you serve any incarceration on the state charges in Tennessee?
About a week. I served a week in Tennessee initially for the state charges.
Mm-hmm.
Yeah, I served. I'm sorry, excuse me. A month. I was in jail for about a month before we actually were bonded and pleaded to the Tennessee case.
When exactly were you arrested in Tennessee?
One moment. It was 2000. You said where or when?
When?
It was also 2016 later.
What month?
I want to say July or September. I apologize if specifically I don't have the records in front of me, but July or September of that same year.
I see. So when were you released? When was that case completed?
The state case?
The state case.
I was released a month after that initial date when I was arrested.
So you're either out in August or you're out in October, having served about a month and then pled guilty to the Tennessee state credit card fraud charges.
Yes, sir.
Okay.
Yes, Your Honor. Excuse me.
All right. Next question. Excuse me. When was a federal warrant issued?
the federal warrant, after I was able to receive the discovery, and 9 months after that, there was actually a warrant out, but not until about a year after was when I was pulled over, riding with someone. So 9 months from the release, there was a warrant set out per the federal emails. And 3 months from there is when I was pulled over. So it was January 6th, 2018. When I was actually, yes, when I was arrested, sir. I'm sorry about that. Your Honor, I can't see him on this screen, but maybe,
Is there anything on that screen?
no, there's no mouse or something. Maybe it's a
Oh,
screen
yeah, that's
share.
not helpful.
I can see that. I can see that.
Let me see if I can turn that one on. Hold on.
But I can hear him.
Hearing him is important. It would be helpful if you two could see each other. I didn't realize that screen wasn't on. I don't have the ability to turn it on, unfortunately.
Screensaver like it's asleep or something. I mean, there we go.
Why don't we have Mr. Richmond sit at the prosecution table?
Sit there. Okay.
Yeah.
I'm gonna sit here.
Is that okay? Okay. Yep. So sit in front of that screen. The microphone will pick you up, and then you can see Mr. Getachew Smith, and he can see you. He actually just disappeared. Hopefully he'll dial back up. You didn't make him disappear, did you?
No, sir.
All right. Now we can see you. Hopefully he'll dial back in. We're going to need to take a break in about 5 minutes for about 15 minutes. So I need to deal with something back in chambers, and then we'll pick back up. But I'm going to sit tight, see if we can get a few more questions in from him.
Thank you, Your Honor.
Here he is. You're back. It's not showing an audio feed for you, Mr. Getachew Smith. Can you hear us? Oops. You may need Mr. Getachew Smith Jr. to help you with this.
Hello, can anyone hear me?
Yep, we can hear you now. Can you hear us?
So, Your Honor, what happened is that we lost power in my neighborhood. Everything cut off.
Uh-oh.
So that cut off, I guess, my internet connection. So I'm on the phone.
Okay, well, thank you for being resourceful. Do you have candles ready?
Let's hope it comes back on before the night. Yes.
Okay. So here's where we are. I have to step away in a couple minutes to handle
All
something
right.
in another matter, and then I'll be back. But I wanted to let you know we moved Mr. Richmond. I didn't know you could not see him, and I didn't know that the screen at the witness stand was just sitting there. So now you can see him. He's at the table labeled prosecutor. He just waved at you. He can see you, which is how I learned about
Yes.
this. He said, I can't see the guy. Now you can see each other. You had asked, you were asking Mr. Richmond about when he got picked up on the warrant for the federal case. If you want to finish that timeline before we break, that's great.
Okay. Basically, I was asking, when was the warrant issued? I know that he was picked up on the warrant on January the 6th, 2018. I wanted to know, when was the warrant issued?
The warrant, I'm sorry, I said a year, but after recollection, the warrant was issued that the prior October, October of 17.
October of 2017.
Yes, sir.
So, hold on for a second. So, let's see. So why was there a gap between the time of the issuing of the warrant and the time that you were arrested as a fugitive?
Why was there a gap, sir?
Yes.
Because I didn't know I had a warrant, and federal warrants, there's no way to research federal warrants. If I would have known I would have had a warrant, I would have either turned myself in but that was the reason for the gap, because I didn't know I had a warrant, for a federal case. And yeah, I would have.
Okay. I don't have any further questions right now, Your Honor. That's it.
Okay. Mr. Franklin, do you have any follow-up for Mr. Richmond?
No, sir.
All right, well, this is a natural break point. It's a couple minutes before I have to get on this other call. I apologize for leaving folks for a few minutes. I'll get back here a little bit before 3, and we will do argument about the 4 Barker v. Wingo factors. As I understand what Mr. Franklin just presented through his client and his witness, would be evidence that would go to that 4th prong, prejudice to the defendant. But we'll talk about the other 3 and the 4th when I get back. Anything else procedurally, Mr. Franklin?
No, sir.
Okay. Mr. Getachew Smith, does your phone have a good battery on it?
I can, oh, that's right. I can't plug it up. Well, I hope so.
Well, why don't you do this just to preserve?
I'll turn it off, Judge, and I'll come back at 3 o'clock. Is that the right time?
Yes, come back at 3 o'clock, and that will preserve 20 minutes of battery, okay?
Okay, sounds good.
All right, thank you.
Thank you.
All right, gentlemen, I apologize. This was supposed to start earlier, and we would have been done before this other thing, but then I had to deal with Assembly Hall and our upcoming jury trials. So I will be back as close to 3 as I can make it. Thank you.
So real quick question. So he's off the stand, so I'm okay to talk to him now.
Yes.
Okay, thank you, Your Honor.
Service unit code 1870.
just look at myself.
Mr. Franklin, can you give me the name of that case you're gonna cite?
Yeah. Hester v. State,
How do you spell that?
Hester,
Okay, thank you.
and Hayes v. State, Hayes. I think those are the only ones I would cite.
Okay, thank you.
You're welcome.
Okay. I didn't know if you saw.
No, we just, testify.
I heard that.
And she's my trial partner.
Nice to meet you. So, nice to meet you.
Is your plea exactly? Your guest is coming in, or she?
I see her on the Zoom, so I think she's gonna do it.
Hello. Let me see. I may need to. There's Mr. Gatacho Smith. So there's some people who have joined. Ms. Patel, would they be for the plea?
Yes, Your Honor, I believe my client's sister and mother.
Okay, I'm going to move them to a waiting room. So, hey, if you are, is it the Palmer, the name of the case? If you're on the call for Mr. Palmer, I'm going to move you into a, whoop. You didn't have to go. Okay, that's fine. You stay right there. I'll let you know when we're shifting to that. I need to see if I can extend the length of this meeting so we don't lose it. Okay. Okay. One other sign in. Ms. Nelson, if you know how to extend the meeting, if you want to send me a text about that, I'll do it. I'm trying to figure out. I see it here, but I'm looking at the invite, but I don't understand. I don't know how you make it longer. But we'll figure it out. I'm gonna get back to Mr. Richmond's situation. All right.
Okay, Judge, I'll try to see what I can find out.
Pardon me?
I'll try to see what I can find out. I don't think I have that capability, but let me research it.
Okay, if someone tells me how to do it, I think as host I can do it. I don't know what one does. All right. Mr. Franklin, legal argument about the motion to dismiss.
Thank you, Judge. So as the court has already alluded to, there's a two-part test. You discussed the first part of the test, the threshold of whether we meet this 1 year presumptive line of some prejudice. And of course, we have met that in that this accusation was first made by the complaining witness March 10th of 2016.
But it's not when the accusation, it's when your client was arrested.
Correct. And he was
Happens to be the same day.
happens to be the same day.
Okay.
So yeah, he was arrested on March 10th, and I believe the actual date of the indictment is April 5th, and that is 2019. So that is a period of just over 3 years, and as you've kind of already addressed, that threshold is not a question for us likely today.
Mhm.
That brings us to the 4 factors as laid out in Barker v. Wingo. Those factors, of course, are the length of the delay, the reason for the delay, and the assertion of the right to a speedy trial, and finally prejudice to the defendant. To begin, as I laid out in my motion, the time frame that we're talking about is from the arrest or indictment, so the arrest in March of 2016, until the point in time where the motion to dismiss is actually held, which is, of course, today. We are 1 day short of 5 years. And so that is a remarkable time. And I think to fully understand that, we need to kind of discuss a bit of the reason for the delay. Mr. Richmond was not indicted until, like I said, 3 years later, at a point in time where he was in custody elsewhere. He wasn't aware or anything of that nature. More importantly, I think we've often had people who miss court, and they are a warrant of some sort is placed on them so that when they are released from another county or anything, it'll pop up on the system such that the persons, when they're released from their current facility, they get a free bus ride to Fulton County to answer to the charges. Mr. Richmond had no such ticket awaiting him. He was released in September of 2019. He had not been brought to Fulton by Fulton authorities, and that would suggest that no one from the Fulton County District Attorney's Office made any efforts to secure his presence, despite the fact that they had at least on August 27th of 2019 become aware that he was in federal custody. I'm going to lay out
Tell me, August 27th, 2019.
2019.
They're aware he's in federal custody because
we had a status hearing. This is when it was still with Judge Reeder.
Okay.
And I was present at the hearing, and I informed the court that we couldn't address status.
Okay.
Because he was currently in custody.
Okay.
And at that point in time, nothing else was done until Your Honor inherited Judge Reeder's calendar, and I guess you got a list of cases, and you decided to kind of get a status on where everything else is, and that you held a status hearing on March 16th of 2020. And Mr. Richmond was free at that point in time. He traveled from New York and was present in court for that hearing. We, at that point in time, established that I had not received any discovery, and that a reset to June 23rd of 2020 was the next court date. That was plea and arraignment. So we get to the plea and arraignment court date. At that time, I am fairly certain that Marshall Hodge was the DA on the case at that time. I think
if I was involved, when I started, she had transitioned to replace someone.
Yeah. And we agreed to a scheduling order. Your Honor signed and issued a scheduling order on July 1st of 2020. And it laid out the discovery would be due by August 5th. And I think part of the reason for that quick turnaround is this was an older case. There should already be discovery present. So it was just kind of a buffer, if you will, to give the state some time to actually copy it and hand it over to me. August 5th passed, and it was not until October 8th, thereabout. I may have received it a day before or so.
That's when it got filed, October 8th.
Yeah. So discovery was not served until October 8th. It was not until that time that I had the chance to kind of see what the state exactly had. I had some knowledge of of course, what the charges are because of the indictment. And, I was able to talk to my client about what he remembered about it. But of course, it had been 3 or 4 years at that point. So
So before, I'm sorry to interrupt, but before October 8th, 2020, you basically had what we'll call a complaint package. You may have had, you had the indictment. I know that.
I had the indictment.
And you may have been able to fish out of the system an arrest warrant. But that's it. You didn't have police reports. You didn't have witness statements if they exist. You didn't have DNA tests or a sexual assault kit. Nothing.
Correct.
Until October 2020.
Correct. And I will go further to state that after reading the discovery, not surprised, but of course, a rape kit was stated as having been performed. I've still not received that. So there's still discovery outstanding to this day. So as we get into the reasons for the delay, I don't think that there is a fair question to be had about the first 3 years up until indictment. The discovery that I've received thus far shows that the investigation was essentially completed within a couple of days. I'll say within the week of the allegation, just to provide a bit of a buffer. But aside from the interviewing of Mr. Richmond, the interview of the complaining witness, and the rape kit, which I've yet to receive, I'm not aware of any work that the police department nor the district attorney's office engaged in such that it will warrant a 6-month delay, much less a three-year delay. So certainly those first 3 years, the district attorney's office. So then the question, there's kind of another compartment of time, the time from indictment until the filing of my motion. So that would be from April 5th, 2019. And I filed my motion November of last year. I did not file my motion because I had not received discovery. Additionally, I had not filed and I'll address this in the next factor, I had not filed a statutory speedy trial demand because raised up in the Fulton County Public Defender's Office, I understand that when I file a speedy trial demand, I'm saying that I'm ready for trial. And I certainly cannot make such a representation without a basic police report. So additionally, by the time that Mr. Richmond had been released from federal custody, the window for a statutory speedy trial demand had passed. If this was if the indictment came in April of 19, that would have been the March-April term of court. And I believe you have 2 terms of court after that for this type of charge, which would have been May, June, and July, August. We had a couple of conversations over the phone just to figure out, hey, are you my attorney? Myself and Mr. Richmond did while he was in federal custody in Alabama. But aside from that, we hadn't had any real meaningful conversations at that point. And so I believe that this middle portion of time is attributable to the state as well, in that even once it finally took an affirmative action towards prosecution, it half-stepped. It said, we're gonna give you an indictment, and they forgot about it once again. As it goes towards the assertion of his right to a speedy trial, I think that Mr. Richmond did all that a person could reasonably do at that point in time. I guess it kind of largely fell off of his radar to some extent because he was dealing with other issues. He was dealing with federal charges unrelated to this case. And in attempting to figure out how he could, gain good time or, get out to a halfway house, he became aware that this Fulton County case was still pending, such that a disposition was needed. So he took efforts on his own to reach out to the clerk of court and say, hey, I got this case, I'd like to resolve it so that I can take some classes here in federal prison towards rehabilitation. I would argue, though there's no way to actually show this, that letter served as a tickler of some sort, such that it reminded the state to go ahead and present the case to a grand jury. Otherwise, it's just a really coincidental timing, and that they waited until 4 years at that point to, well, 3 years at that point to go ahead and indict him. I would also, as I alluded to earlier, I would stand flat-footed and assert again that the filing of a traditional statutory speedy trial demand just was not a practical response, given his positioning, his inability to have access to an attorney to say, hey, when I get out of here, let's go have a trial in Fulton. And so I believe that his reaching out and saying, I would like to resolve the case is a suitable and reasonable exercise of his right to have a trial and to deal with the case at that point in time. And so we get to the point where we are pre-COVID. We've heard testimony from, we've heard testimony from Mr. Richmond that once he was released in September of 19, that he went to New York, he's tried to get employment. We provided evidence that he tried to get employment, and that, again, the same way that these charges prevented him from taking rehabilitation classes in federal prison, the same way that these charges prevented him from taking these classes that may have allowed him to shorten his time in federal prison, that he again was kind of confronted with the obstacle and the stressors that a charge of this nature would present for a person in custody. He had jobs previously, even before, like when he was first released on bond, that he lost, per his testimony, because he disappeared for a month. His employers asked what was going on. He informed them of the case, and he suffered a level of a loss of employment because background checks were required of certain things, and he couldn't pass one. So he does freelance work. He was able to do some work, but not to the level that he had done previously. I think this is most evidenced by the fact that he engaged in a criminal scheme, one that certainly would suggest that it was motivated by money, one that there's no evidence that he was involved in prior to these rape allegations, because he, like as he stated, he hadn't been in contact with his public defender, wasn't quite sure how that was going. I could speak to that some as an employee of the office and say that, you know, if you're unindicted and you're out on bond with a complex charge, there's not much communication at that point in time. He talked to some attorneys, realized they were out of his price range of what he could afford at that point in time, and he made a bad decision in choice of activities to try to get money to fight a very serious case. So that all goes towards the prejudice, the fourth factor, the prejudice that he exhibited, that he experienced. And I think that even that factor, we've kind of gone above and beyond, because as we sit on the doorsteps of the 5-year anniversary of his arrest, 5 years, as stated in the Hester v. State case, the extraordinary 5-year length of delay raised the presumption of actual prejudice and thus did not require Hester to make a specific showing of prejudice. There is a point where the delay in getting to the hearing and trial is so long that even the court is in a position where it has to say, even if Mr. Richmond hadn't testified to his job loss, to the strain on his mental psyche because of his inability to care for his children as he had previously done, his inability to even petition for custody of his child, who only ended up in the child who lives here in Atlanta, even if he was in position to petition for her custody, he couldn't now because he certainly would not be granted custody with an open rape charge.
Right.
I think that's a very obvious calculus for even a non-lawyer to do. And she only ended up in the grandparents' custody because the mother was, as he stated, dealing with some mental health issues, and the courts, it seems, accurately determined that that was the most stable place for her to be at that point in time. So there is actual prejudice, additionally, in that he attempted to go back to the residence where he lived at the location of these allegations and see if any of the people were still around, to see if the landlord may have still had paperwork from the guys who lived there. And he had a couple first names. I think the court saw him trying to struggle to remember a couple of people's names. That was Terrence. He made mention of
Alex, the Russian
guy, and there was an old guy. I believe he said his name was Chris. We learned that these are people who Mr. Richmond has said they were all out, kind of hanging out in the the steps of the area. We believe that they would have been able to provide some testimony as to how Mr. Richmond and his accuser had been interacting, and that would have certainly been helpful, though not necessarily dispositive of the allegations that arose when they were together privately in his bedroom. He described the home, and even if like the testimony of what their interactions were like in this public setting was not super convincing, this is basically just a house. It's not like a unit where you have a great level of privacy. It's a unit that didn't have a refrigerator, where people on the same floor shared a bathroom. And I think we can imagine it's just a wall, and it's not any kind of special wall to separate a unit. It's a wall separating a room and a house. So we can imagine that things could have been heard. Testimony could have been provided to that regard. But one, it's been 5 years. Even if we were to find those people today, what they remember about this random night for them from 5 years earlier certainly has faded to some extent. And we're not even in a position to kind of find them because the landlord had no records at that point in time. Mr. Richmond asked about cameras. Certainly no cameras footage existed. And I think we could have made that argument without Mr. Richmond's testimony, but I think it certainly helps that he went to the location himself and tried to scurry up some evidence. But nevertheless, the prejudice factor of the Barker v. Wingo test, there are a couple of ways that courts have kind of stated that it could be shown. There is the incarceration aspect, where being held pretrial is oppressive. We're not arguing that that's present in this case. There's no ground for that. He got out after a month. At the time,
bulk of the time he did was a different case.
It was on a different case. However, I do think the other recognized factors of this, the other recognized sub-factors of prejudice, one of the purposes of this is to minimize the anxiety and concern of the accused. I think that his testimony regarding that he naturally was an extrovert, but understandably because of these charges, he feels as if people see his charges when he's out. Whether that's rational or irrational, I think is accurate in that a person charged with this nature of crime would be hesitant to socialize. The allegations are, for lack of a better term, of a social variety, right? The other way is to limit the possibility that the defense will be impaired. There has already been a possible loss of camera footage. There were cameras there, as Mr. Richmond testified to, and there's no indication from the police report that police did anything to obtain footage or preserve footage. And it certainly has not been turned over in discovery if it still exists anywhere. The defense has been impaired to the extent that we don't even have a way to figure out how to track down witnesses who would have been able to offer some context to the interactions between Mr. Richmond and the complaining witness. So again, we have the fact that because we're at this 5-year delay mark, we don't have to show actual prejudice, I would argue, but even still, I think we have. And so I think we kind of achieved that result on two different grounds. And so I think all four factors weigh in favor of Mr. Richmond in this analysis. So the length of delay is uncommonly long. The reason for the delay The only part that I think the state would have some argument over, but I think in the end they have to, the blame has to fall on someone and it will still fall on them, is that we've not had a trial in Fulton County for a year because of COVID and Corona.
It's not the state's fault.
It's not the state's fault.
Not the defendant's fault either. That might be a chunk of time where we really don't blame anyone, but the prejudice still falls on the defendant's shoulders.
Yeah, and I would still even argue that the large majority of the time, certainly from whenever court shut down, March 12th or 13th of 2020, around that, certainly up until at least when discovery was served. Again, when COVID started, we still haven't received discovery. Certainly up until the point of discovery was being served, there's not an argument that the state had done anything that wasn't negligent in the prosecution of Mr. Richmond. They had not been diligent in their prosecution of Mr. Richmond. It would have been 4 years and 6 months at that point in time. So we're talking 4.5 years before you even provide discovery. And I will also add in, I first, and the court records obviously will reflect, I filed and served my entry and my discovery request in May of 2019. So shortly after I get this random phone call from a guy in federal prison in Alabama, talk to him a little bit, want to be able to kind of jump on it whenever he's released. I filed for these file discovery. I served upon Dallas Cox, who was employed with the district attorney's office at that point in time. I'm not sure if he's back, but I think he left and went to Cobb County, I want to say. But I made discovery requests in 2019. And so it took over a year, about a year and a half to get the discovery that I requested. So it's not even it wasn't brought to the DA's attention that this is, a plain arraignment in 2020 that, we need to get some stuff done. No, I had served it and did what I should have done as his attorney a year and a half before. So again, that kind of leaves this last little window between the end of October until now, October 2020 until now, when maybe the state can kind of take some of that blame off of its own shoulders. I will say, I believe we were scheduled to have this hearing first in January.
We've had two. I was going to ask you, it doesn't change much. I mean, we're into the 4.5 year mark by then, but this was supposed to happen on a day during your December. And I think you were willing to come in. I don't remember why we had to reset it, but December 8th was the first time we were set to hear your motion. And then January 19th, we didn't hear it then either. I just don't remember why.
Yeah, I would say one of the times was the date came up super fast, and I say faster than that I wasn't aware that it was coming up, and Mr. Richmond wasn't able to come down to provide testimony. And I always demand that state's witnesses are here to provide testimony, and it would have been very hypocritical of me to say, hey, I'm going to let my guy testify from his living room in New York.
So one of the continuances, you asked for it because you couldn't get your client.
Correct.
Okay.
So my understanding, the last continuance, and perhaps Mr. Gatachu could provide some clarification, or there may even be an email about it if I search for it. I'm not sure Mr. Gatachu was sure that he knew that he would be the person handling it. And he may have come to court or emailed Ms. Nelson, the case manager, and said, hey, just learned about this. Can we get another date? And I consented to that.
Okay. So you think the first one, the December one, you asked for the continuance, and then your recollection is the January one, the DA's office is in transition. It's only been the new DA for 15 days.
Yeah.
That the DA's office asked for.
Yeah, I thought the dates would have been January and February, but if it's December and January, then yeah, that would be a fair characterization. So one continuance that amounted to about a month could arguably be because of myself, but the other would certainly be because of the state.
Okay, got it. Mr. Gatacho Smith?
All right, thank you. Can you hear me, Your Honor?
Yes, sir. Can you hear us?
Okay. I can, absolutely.
Great.
I do have electricity, so we're on the upswing. Thanks
Welcome
for
back.
that opportunity to allow me to run to the Georgia Power office and pay my bill.
Good.
So the state contention is that the defendant's claim is without merit. and this court is urged to deny the relief requested. We concede that the initial threshold has been made. So we will move on to the 4-part test of the Barker v. Wingo analysis. And the first factor is the length of delay, and where the pretrial delay exceeds the amount of time necessary to establish a presumption of prejudice, delay is considered uncommonly long. Based on case law, it's the state's position that any finding of this factor should not be held heavily against the state. In the case of Milner v. State, Georgia Appeals 329, Georgia Appeals 654, that's 2014 case, and uncommonly long 10-year delay was determined not to be held heavily against the state. The Milner court opined that we have previously found delays of similar length may be weighed against the state, but not heavily. The defendant contends here that we have a delay of in the range of about 55 months, 59 months between the arrest and the motion to dismiss indictment. The state asserts that the delay is actually less. Of the 23 months post-indictment, only perhaps 9 months should be counted, since there was a judicial emergency order in March of 2020 that suspended some speedy deadlines. And some of the pre-indictment delay, which was about 37 months, is attributable to a number of factors, including crowded dockets, the assignment of multiple ADAs, the fugitive status of the defendant, incarceration out of state for approximately 24 months, and also the victim herself was out of the state. There are no allegations that the delay was intentional to gain an advantage. So therefore, it's the state's position that at most the length of time cuts benignly against the state. As to the second factor, reasons for delay, here, once again, there's no evidence that the government deliberately delayed trial, and rather delay can be attributed to benign reasons, such as the GBI took a year before completing their analysis. And for 24 months, the defendant was in federal custody outside the state. The victim moved out the state. And as I said before, there were crowded dockets and multiple prosecutors. And according to the case law, when no reasons for delay, it should be treated as being caused by the state's negligence. And when the state is unable to explain with specificity why the proceedings were delayed, thus resulting in a finding of negligence, that negligence is treated as benign and weighs only slightly against the state. So our position is that this factor should be neutral, and at worst, it should only be weighed benignly against the state. The third factor is failure to assert. Here, there was no statutory speedy motion. And to the extent that the defense asserts that the defendant's letter dated December 3rd, 2018 was a speedy motion, it is important to note that the letter makes no mention of the term speedy. At best, it was a demand for trial. And our Supreme Court here in the state of Georgia has held that a demand for jury trial does not invoke a constitutional right to a speedy trial. The case that holds that is Over v. State 302, Georgia, App 215. That's a 2010 opinion. Also, a pro se demand for speedy trial while a criminal defendant is represented by counsel is of no legal effect. That's State v. Porter, 300 Georgia, App 128, 2009 opinion. Here, there was uninterrupted representation by the Office of the Fulton County Public Defender. Appearances were filed by Overton Theory and Devin Franklin. There was no discharge of counsel in the record, and nor has this defendant been through the Ferretta advisement process. The motion to dismiss indictment on constitutional basis was not filed until approximately 4 months ago, and that took place during the pandemic emergency. A delay in asserting suggests that the defendant had not sought or knowingly acquiesced in the delay. And it has been held that where the defendant filed no statutory demand for speedy trial and did not raise his constitutional right to a speedy trial between his arrest and the file of the motion to dismiss, which he finally asserted the right, this factor is entirely to be given strong evidentiary weight against the defendant. And that's Watkins v. State 267 Georgia Appeals. That's a 2004. So the state is in total agreement that this factor should be weighed heavily against the defense. The fourth factor is prejudice, which causes the court to examine three interests. First is preventing oppressive pretrial incarceration. Here, this defendant was granted a bond within 2 to 3 weeks of arrest. All subsequent incarceration was the result of inapplicable and unrelated federal charges. There were no allegations of oppressive conditions while incarcerated in Fulton County. And so it is the state's position that this subfactor should not be held against the state. 2, minimizing anxiety and concern. And it's been held that the fact that the defendant failed to assert his right to speedy trial earlier has been interpreted to suggest that the defendant was not suffering from anxiety or undue stress. Here, no such showing has been made. The defendant did not assert speedy until very, very recently. And so therefore, we believe this subfactor should not be held against the state. Third and most important factor is impairment. Impairment is the most important one because it pertains to the inability of a defendant to adequately prepare his case for trial. And the courts have cautioned that presumptive prejudice does not carry a Sixth Amendment claim by itself. In fact, in Barker, they recognize that delaying a case or acquiescing in delay is not an uncommon defense tactic, and held that barring extraordinary circumstances, we would be reluctant indeed to rule that a defendant was denied his constitutional right on a record that strongly indicates, as does this one, that the defendant did not want a speedy trial. And the Barker opinion also stated that delay does not per se prejudice the defendant because it can tilt the case in favor of the defense or the prosecution, and one cannot generally be sure which of them has been prejudiced the most severely. To demonstrate impaired defense, one must make more than just vague or conclusory statements. There were no such statements in the filing by this defendant. And here today we've heard that perhaps there were witnesses that cannot be found. There's camera footage that cannot be found, etc. We believe that could have cut either way. Who knows what the witnesses might have said or what the footage might show. And in fact, we don't even know if there were any cameras, period, here. So when balancing the factors, we conclude that the lack of oppressive incarcerational conditions and the failure to assert anxiety concerns and the lack of any specificity regarding prejudice, we believe that prejudice cannot be held against the state. I can go over the first factor. We believe uncommonly delayed weighs against the state.
No, you don't need to do that. I think that's the least complex.
Yes.
But I want you to, I haven't had to perform this analysis in a while. What you're saying, Mr. Getachew Smith, is that you believe the case law supports the notion that explanations from the state for the delay of we were busy, different prosecutors, that those sort of benign neglect explanations, it's not that they make this situation acceptable, but they mean that the reason for delay is not held so harshly against the state, as opposed to a purposeful delay because the witness who was going to be difficult for the state was on life support, and if we just wait long enough, she'll expire.
Absolutely. That's what we're saying.
Okay.
That's intentional on the part of the state and nothing to be gained by the state by the delay that has occurred.
Okay. Got it. Thank you. Mr. Franklin, anything you want to say in conclusion?
Yes, sir. The first part that I will address, and I want to make sure I heard this right from Mr. Gatachu Smith. He stated that the GBI took a year to finish its work, and that was somehow related to the delay in indictment. Did I hear that correctly, Mr. Gatachu Smith?
You did.
Okay.
I have some dates. Yeah.
Go ahead, Mr. Gatacho Smith.
So the GBI on May the 12th, 2016, identified there was human male evidence on the vaginal swabs, and they were submitted for DNA analysis. It was not until April the 25th, 2017, that they determined there were two profiles. There was both male and female, and they entered it into CODIS. And then a month later, on May the 23rd, 2017, the GBI issued a CODIS report confirming that the DNA matched the defendant. So that was over a year of the pre-indictment period.
So I thought you said, Mr. Franklin, that you don't have anything like this. Is this news? Hearing this is news to you?
I don't have that.
Okay.
That was not, and that's not on Mr. Gatachu Smith.
No, not at all.
Whoever served the discovery, I don't have that report. Nevertheless, I mean, one thing I would say is, I mean, you've been a judge since before I started practicing, I believe. There are cases that we have on trial calendars that have been indicted and been in courtrooms for a while that still have GBI lab results pending. We've had to reset several things several times. It's kind of a matter of course somewhat, given the volume of things here in Fulton County. So for Mr. Gatachu Smith to assert that, oh, we didn't indict him because we wanted to wait for some lab results to come back, that does not ring true when looked in the totality of how cases have been prosecuted in Fulton County by the DA's office, at least under that prior regime of Mr. Paul Howard. Cases were regularly indicted. Cases were regularly continued off of trial calendars.
You may be right, but what I take Mr. Gatacho Smith to be saying is whether you are looking pre-indictment or post-indictment, the state would not have been able to go forward and it would have said you need to delay this, judge, because GBI hasn't done what it needs to do. I don't know that it's particularly consequential that it was before or after. What I'm hearing Mr. Gatacho Smith say is you can't pin that on the DA's office just twiddling its thumbs or trying to do something that is destructive to the defense case. They're stuck waiting on the GBI. Here they happen to wait pre-indictment. That is atypical, but that's what happened. Whether they were waiting or they had forgotten about the case, they could not have gone forward to the point of trial because things were in the queue at GBI. I'll weigh that how I need to weigh it based on the case law. I don't think it matters so much pre-indictment versus post-indictment. It's a factor for the state to point to of out of our hands.
Understood. I will add that the importance of me kind of focusing on the indictment point in time as it relates to this case in Fulton County, in this non-complex, complex delineated system that the court at least has some familiarity with, it's not unknown or uncommon knowledge that a person charged with a complex crime does not meet with their attorney or doesn't know or have a way to identify an attorney who will work their actual case and presumably be with them until trial, until an indictment occurs and the case is assigned to a judge or a courtroom. So even to that extent, again, there was a possibility to indict so that the process could move quicker and more efficiently. And we were only able not to do that to have this discussion about missing discovery and missing GBI reports because of the state's delay in that regard. Everything the state says in terms of the reasoning, I'll just kind of leave that to the court to weigh. But again, whether it's a heavy balance or a slight balance, it's certainly such that it weighs against the state. And given the deficiencies we've discussed regarding ability to kind of follow up on evidentiary leads, It certainly weighs against the state, but I'll leave it to the court to say it's a lot or a little or not. I will also like to respond to Mr. Getachew Smith's assertion that it's kind of because Mr. Richmond did not file a statutory speedy trial demand, that's kind of a end all be all to that particular factor. I would cite the State versus Allgood 252 Georgia Appellate 638, and that's Allgood, ALLGOOD from Ms. Karen. In that case, the court recognized that regardless of the procedures mandated for a statutory demand for speedy trial, a defendant has the right to assert a constitutional speedy trial demand at any time after arrest. And since the filing of a speedy trial demand is not a prerequisite for a plea and bar for failure to have a speedy trial on constitutional grounds.
I saw it was in your brief. I think we're spending too much time on the value of Mr. Richmond's letter. It couldn't have been a speedy trial demand. He hadn't been indicted yet, so it wouldn't have been a statutory speedy trial demand.
Right.
There was no indictment. Was it a tickler? Chronologically, it comes 6 months later. There's an indictment. I don't know. But certainly he's doing what he can,
correct,
to wave his arms to the system of which you and I and Mr. Getachew Smith are a part, saying, I'd like to deal with this. Here's some prejudice I'm experiencing because these charges are just floating around out there.
Yeah, but more so than the fact that we're saying that this letter is a substitute of sorts. What we're saying is that I believe this case law supports the contention that the fact that he didn't file one at all, if he hadn't even written a letter and we're just dealing with the fact that
it's not a bar. It's not a bar. It's just, it doesn't help.
Yeah.
If you had filed a speedy trial demand, maybe you withdrew it because of X or, but a speedy trial demand could have been filed. One wasn't. That's a factor that I weigh, not in your client's favor, but it's not dispositive.
Correct. And again, in terms of the weight that, I'm sorry, were you saying something, Mr. Smith?
I was simply saying that I never argued the fact that he did not file a statutory speedy was dispositive of the issue of assertion of the right. I just said that was just one of the things that I mentioned.
Yeah, I agree. I'm sorry my video wasn't on. I was nodding my head. I agree, Mr. Getachew Smith. I didn't hear it otherwise. That's why I was saying I don't think we need to focus on the letter too much. It's helpful to the defense in one way, but it doesn't advance things in another way.
Agreed. I was essentially agreeing with the court that we shouldn't focus on the letter, because even if we had no letter or anything,
right,
he still did not have access to an attorney during that point in time where we could have asked for a trial or done anything meaningful, because we again did not have discovery from the state until October 8th of last year. And that is essentially the rest of my response, Your Honor.
Okay. Mr. Getachew. Yes, sir.
Just a couple. One, I just wanted to go back to the issue regarding the amount of time, et cetera, that the state believes that there was enough blame for all. And perhaps this case would have moved forward a lot quicker had not his client been involved in additional criminal activity, which therefore had some effect on his ability to contact his lawyers or to contact the courts. Likewise, when we start talking about prejudice, and anytime someone gets involved in the criminal system, it will have some effect on them. But we cannot ignore the fact that in addition to this case, that Mr. Richmond is a convicted federal felon. And I'm sure that had some effect in terms of his ability to find employment and other opportunities. And likewise, this has affected our client. I mean, we have someone who has been exposed to rape and probably will result in trauma for the rest of her life. And she's made it very clear to us that she wants to go forward with this.
So the question I would have, if I understood, so Mr. Getachew Smith is asserting that because Mr. Richmond was incarcerated on other charges, that the state could not have went forward with an indictment because they didn't know where he was?
I didn't hear him say that. I heard him say that well, I heard two things. One, on the prejudice prong, there may be a few other things in the hopper when a would-be employer is deciding what to do with an application from Mr. Richmond, because there's a state and a federal conviction in play for these applications in 2020. I'll read the exhibit. It may have only said, we're scared of the rape open charges, but we're fine with credit card fraud, even though you're going to be working in a furniture warehouse. So that's a point well taken, that there are complicating factors. I took the observation about the period of time when he was in federal custody to mean not that the state couldn't have indicted the case, but maybe they indicted it on month one.
And he said they couldn't have had a trial at that point in time because he was in federal custody. And my response would then be that argument is essentially baseless, in that we're playing a what if game based on things that the state had control over. We may not have been able to have a trial when he was in custody, in federal custody, if he was indicted and otherwise would be available.
But we also couldn't if he wasn't indicted.
But the fact is, the state, who I'm not sure if there was other restrictions that we have now that kind of stopped them from having grand juries, but in 2016, 2017, 2018, there were grand juries and they chose not to bring that case forward. And I'm not sure if they had communication with the complaining witness at that point in time either. But again, that's a would-be if consideration that the actual facts that we live under don't support.
Okay. Mr. Getachew Smith, I would like you please to reach out to the prosecutor handling the case. I think that will be Ms. Patel.
That is correct.
And see what she has to say about discovery. I need her and Mr. Franklin to chat real briefly. Your recitation from a GBI report, it sounds like Mr. Franklin doesn't have. I need Ms. Patel, or you, but it seems like it would be her role, to check what she believes attorney number 3 or 4 on the case gave to Mr. Franklin. If it was provided to him, then he shouldn't be so surprised to hear you read from it. If it was not provided to him, that's an additional issue that I'll need to work through, in that the state provided discovery late and incomplete and left out what sounds like a pretty compelling, for the state, piece of evidence. I'm not saying they left it out, but Mr. Franklin's saying that's news to him. You certainly didn't put together the discovery packet. Unfortunately, neither did Ms. Patel, but she's going to need to figure out what she believes the state did provide. And I just need an email to Ms. Nelson after the lawyers have conferred, where either we disagree as to whether it was provided, or mea culpa, it was not provided, or egg on face, it was provided and I didn't notice it. I just need to know what the answer is.
I will.
So I'm going to not rule on this until I get that nugget. It's not going to make or break it, but it will. It may fit into a theme that I see in the way this case has moved. So I'd like to get that. So maybe by the end of next week, you all could get an email to Ms. Nelson, letting her know what happened with the GBI information in terms of a discovery packet that was given to Mr. Franklin. Okay?
Yes, sir.
Mr. Franklin, anything else for Mr. Richmond? Mr. Richmond, I have heard a lot of helpful information from both the prosecutor and your lawyer and your testimony. I've got a bunch of pages of notes, and I need to process all that and line it up with the case law. Unfortunately, you're not the first person to say, I've been waiting a bunch of years for my trial. So there is a lot of case law that says, judges, here's how you're supposed to weigh it, and you shouldn't put too much emphasis on this. This kind of thing is real important. I'll need to look at all those cases, and then I'll enter a written order. If I grant the motion, then the charges are dismissed. I suspect the state will appeal that, so they are provisionally dismissed, but it will be appealed. If I deny the motion, then the case would move towards trial. You would not have lost your ability to argue this on appeal if you were found guilty after trial. So the argument's not lost if I deny the motion. It just means that an appellate court would have to work through it if that's where the case ended up. You remain on bond. I guess you're going to stay up in New York. If you choose to move, you need to make sure you let either the bonding company or pretrial, I don't know who's supervising you, but if you do move, you got to let everyone know so we can track you down, okay? Any questions about anything? Okay, appreciate you coming down here. Mr. Franklin, I'll wait for you and Ms. Patel to talk about discovery and get that answer to Ms. Nelson.
Oh, thank you. Of course, now that you said everything, one other thing did pop in my mind that is very quick.
Okay.
Mr. Gatacha Smith made mention of the fact that Mr. Richmond had been represented continuously and uninterrupted from the point in time he was arrested until now. Mr. Richmond did in fact testify that for his bond, he'd hired an attorney, but it was only for bond purposes. So there was not a, I know when I was in non-complex, if an attorney got into a case that we just saw they were hired, doing it for bond purposes is not really a thing with us, but he hired someone else who argued his bond and got him a bond that he was able to make within a month.
So I heard his testimony and I see the bond. The only entry of appearance before yours is Mr. Terry's on the day of the first appearance. He did what he's supposed to do, which is file an entry of appearance. There is nothing.
And that entry would be one that is filed by another attorney on behalf of Mr. Terry. He would not have been present at first appearance.
Okay, but nonetheless, your office files an entry of appearance. My point was there is nothing in the record to support the notion that a private attorney ever broke the chain between Mr. Terry's appearance and your appearance. Again, not necessarily dispositive. I appreciate you flagging it. And I did hear that testimony. Just the whoever that lawyer was, he didn't get paid enough to file an entry, I guess. He got the bond, but that's where it stopped. All right. Mr. Gatacho Smith, anything else?
No, Your Honor, that's it. Thank you.
All right, thank you for paying your utility bills.
Thanks. Okay. Bye-bye.
Okay, I will get folks out of the waiting room. We are going to pivot now. Ms. Hall, you've been waiting patiently. There you are. Ms. Patel is here, and we've got Mr. Palmer in lockup. We'll bring him out. And Ms. Nelson has figured out how to extend the Zoom so it will not end in 3 minutes.
Keeping our fingers crossed, Judge.
If it does end, I'll do well, I don't know how to do it with all these cameras. So let's keep our fingers crossed.
You have the indictment, Judge?
Hold on, the printer has a red light on it. It's out of paper. Let me put paper in it, but it looks like you tried to send something to it. All right, something's coming out now. Is that the only thing you sent?
Yeah. Yes. Mhm.
Great. All right, so Ms. Patel,
At the desk, the screens went.
Oh, that's,
Well, I guess they would have to go to the podium.
that's,
those screens went away?
Yes, the screens that thing on.
Okay, the podium one is on. I was just gonna ask you where you wanted to be. You both need to be near microphones so that Ms. Rivers can hear you both. We're losing
Okay,
cameras.
so, okay, let me reach out to IT to see if they can come and initiate the camera. So the Zoom call stays, but the cameras go. I think that
I guess
answers my
so.
question.
Yeah, they're gonna need to teach us how to extend it because life happens like this. Okay, the podium is still on, so we can get going. If that turns off, we may have to stop. So why don't you both stand at the podium for now? If we get the others to come back on, then you guys can both be at different microphones, but I just need to make sure Ms. Rivers can hear everything. Ms. Hall, can you hear us?
I can, Your Honor.
Okay, well, we're gonna get started. Get the indictment now that's printed out. So this is case 19 SC 172809. It's State versus Palmer. You're Mr. Palmer?
Yes, sir.
Okay, Mr. Palmer is here prepared to enter a negotiated or non-negotiated plea.
negotiated, Your Honor.
Okay, a negotiated plea. Mr. Palmer, the prosecutor, Ms. Hall, is appearing remotely. Can you see her on the screen there?
Yes, sir.
She's going to swear you in just a moment. Once you're under oath, it's important that you answer all of her questions and mine truthfully and completely. So if any of the questions confuses you or you're just not sure why it's being asked, let Ms. Patel know. You two can talk all you need to before you answer, all right?
Yes, sir.
Okay. Let's get started, Ms. Hall.
Thank you, Your Honor. And Your Honor, for the record, the state will be null processing counts 6, which is possession of firearm during the commission of a felony. Count 7, which is reckless conduct. Count 9, which is discharge of a firearm on the property of another. And count 11, possession of a firearm by a convicted felon.
So that's 6, 7, 9, and 11.
That's correct.
Okay.
And we're also going to take the plea under Section E of 17-10-6.1E. And that is the section that allows you to deviate.
Okay.
At your discretion, obviously.
Understood. Okay. Thank you for sharing that.
You're welcome. Mr. Palmer, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Please state your true, correct, and legal name.
Rodriguez Palmer.
And are you at this time taken or under the...
One second. Yeah, Ms. Rivers can't hear you, so you got to speak up a little bit.
Yes,
Can you
sir.
say your name again?
Rodriguez Palmer.
Okay, great. So just lean on into the microphone. It was
Mr.
good. Got it.
Mr. Palmer, are you at this time taken or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
23. On 9th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 2 counts of armed robbery, 1 count of hijacking a motor vehicle, and 2 counts of aggravated assault with a deadly weapon?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
We waive.
Mr. Palmer, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We do not.
And Mr. Palmer, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum for armed robbery and hijacking of a motor vehicle are both 10 years minimum to serve 20 years max. I'm sorry, 10 to serve 20 in prison. The aggravated assault with a deadly weapon is 1 to serve 20 years in prison.
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 10 years to serve 6 years in prison, balanced on probation, but for all 5 of the counts to run concurrent, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 19 SC 172809, how do you plead to the charges of 2 counts of armed robbery, 1 count of hijacking of motor vehicle, and 2 counts of aggravated assault with a deadly weapon?
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Palmer.
You're welcome.
Your Honor, had this case proceeded to trial, the state would have proven that on October the 12th, 2019, at 2195 Monroe Drive Northeast, that's in Fulton County, Mr. Palmer and a co-defendant entered into a Chevron gas station. Sorry, Your Honor. Sorry, I was trying to get back to the screen. Mr. Palmer and a co-defendant entered into a Chevron gas station where the victim, Mr. Garrett, was leaving out of that gas station. They held him up at the door at gunpoint. Mr. Palmer never had a gun in his hand, though. The co-defendant had the gun. When the victim didn't give up his car keys once demanded by the co-defendant shot the gun in the air inside of the gas station store. At that point, both defendants left out of the store. The victim stated that he saw them go to his car, but when they couldn't figure out where the keys were to start the vehicle, they left from his vehicle and ran over to a white van that was at a gas pump. That car, then they hijacked that victim, Mr. Brandon Carr of that van. Again, that victim also didn't state that Mr. Palmer had a gun, but he did indicate that the co-defendant, Mr. O'Neill, had a gun in his hand when he approached him and demanded his van. Both defendants got into that van, and not even 10 minutes later, they had an accident at the intersection of 7585 South and Fulton Street, where there was a collision between a family car, a van that carried a family in it. They were all taken to Grady for their injuries. The co-defendant in this vehicle was able to move from that vehicle once the accident occurred. Mr. Palmer was actually knocked unconscious when the accident occurred, so he remained in that vehicle when police arrived. They both, meaning Mr. Palmer and the co-defendant, both were taken to Grady to be treated for their injuries. That is all that happened as far as the incident, Your Honor. The defendant's prior convictions, he has one case that he's still active on probation for. It is a first offender case that dealt with entering automobile cases, Your Honor. That was a 2015 case out of Fulton County. He is still on active probation for that. He has 14 years, 7 months, and 1 day remaining. Yes.
What's that case number?
15 SC 140136. And you're welcome. The other open case that he has is 17 SC 155076. And he has 1 year, 9 months, and 25 days remaining on that case. And that is an entering automobile case as well. The only other conviction that he has is a criminal damage out of Fulton County, which is 18 SC 156814.
But that case is closed?
That's correct. It is inactive.
It's interesting. The 15 SC case has good old Anthony O'Neill in it as well. I don't know if you knew that, but the one where Mr. Palmer has 14 years of probation left, or whatever you said, Mr. O'Neill is a co-defendant.
Yeah, I didn't know that. It was my understanding that they met prior to this incident happening.
They sure did.
No, prior to the 19 SC case. So I didn't know that. I didn't know.
Oh, okay. Yeah, they had. They were together in the case that we'll be revoking today as well. Okay.
You said that's the 15 case, Your Honor?
Yes, ma'am. 15 SC 140136. Mr. O'Neill is a co-defendant in it.
I was making sure because I believe, and Ms. Patel will be able to correct me, I believe he's on parole for that case.
Right.
So I'm not sure how the revoke happens on that case, but that's not my forte. But I think he's on parole on that one. He was on probation, then it switched over to, he was on parole on that one. And the one that we were going to ask if you could go ahead and close out is the one that has the remaining 1 year, 9 months, 25 days.
And the 18 SC case is just closed. Whatever sentence he got, that's complete.
Yes, Your Honor.
Okay.
And I just wanted to let you know, as far as us getting to this resolution, Your Honor, I've spoken with the victims in this case. They were going to follow along on YouTube. I'm not sure if they're still around since we started a little late. But the Mr. Garrett, who actually was approached with the gun in the store and was shot in front of, had a pretty extensive conversation with him. And his position as far as this particular co-defendant is that he just pretty much stood there and did nothing, no gun, no force. Of course, he ran with the co-defendant, got in the car, left with him. But as far as trying to take any of his property or actually being forceful with him, that didn't happen with this particular co-defendant. There was never any reports of him having a gun in this situation. There was only one gun recovered from the incident location from the accident. Ms. Patel did send me a list of school records for Mr. Palmer that shows a lot of lack of development as far as educational development for him. Excuse me, I'm sorry. And then there's one big piece to this, well, not big piece, but the final piece that is important to the state, because as you know, you're very familiar with this case. The co-defendant to this case from the very beginning said he was not involved, that he was a pedestrian. Mr. Palmer will testify if that case goes to trial.
Okay.
And then my last consideration was that he does have a history, have some criminal convictions, but they didn't involve any violent history. They did deal with other vehicles and criminal damage, but no violence. But that's all for the state, Your Honor.
Ms. Hall, well, all the cameras are coming back on. Excellent. I'm not familiar with who your new victim advocate is. I know it's not Ms. Rolak, sadly. But there's some people on this call whose names I don't recognize. They may be with Mr. Palmer. They may be connected to victims. I just want to make sure if there's anything I need to hear from any victims or from a victim advocate that I hear that.
Mr. James Williams is my new victim advocate.
Sorry, Judge. I'm on the call too. I did speak with the victims. I do apologize. I meant to introduce myself to the courts. I did speak with the victims, like I said, and also to Ms. Hall about everything that's going on. They did get the link. I've been trying to see if they can get on the call, but we did send them the link this morning too and last night about everything. So they did wish to proceed. And they did not wish to speak though.
Okay. So there's someone that just says iPhone. Is that someone with Mr. Palmer or is that someone from the victim side?
I believe it's with Mr. Palmer. I have no idea who that is. I do apologize.
Okay, it's fine that she's here. It's about to be time to hear from that side of things if we're going to do that. Okay, so Mr. Williams, it's nice to meet you. I got to see you there for about 5 seconds. You and Ms. Hall then have relayed to me what you've received from the victims. And if I were to summarize it, would be in particular from the gentleman who was standing there when Mr. O'Neill allegedly fired the gun, is that he is much more concerned about Mr. O'Neill, and he perceived Mr. Palmer to be, whether you call him the lookout or the strong gun man or whatever, he wasn't the one brandishing the gun. Is that a fair recitation?
That is correct, Your Honor.
Yes, sir.
Got it. Thank you so much.
You're welcome.
Ms. Patel.
Thank you, Your Honor. I'll start with the one thing I just don't want to forget to mention. My client has been in continuous custody from October 13th, 2019. He was loaned out to DOC, and so his current booking screen does not reflect that previous booking. Usually when they do a loan out, it's the same booking, but they treated it like a release and then rebooked him. But he has been in continuous custody since October 13th, 2019. With regards to the case, Your Honor, this case has only lasted as long as it has because my client, before I received any discovery or police reports on this case, was transferred into DOC custody, where he spent several months.
Because he was on parole and got mixed up in this.
Correct.
Okay.
And so he and I never at that point were able to have a conversation about what he was looking at. Once he was brought over, I was able to talk to him as well as his family. This was not a case that he at any point was trying to take to trial. He had always wanted to resolve it. Ms. Hall and I, for a very long time, had been talking about a potential resolution. There were a few things that we were waiting on the state side, and then on my side, I was trying to get school records. Those school records came into play when I spoke to his family to get an idea as to how Mr. Palmer is in the position that he's in. When I talked to his sister and his mother, they both discussed how Mr. Palmer grew up without a father and that deeply affected him. When his mother moved to, I believe it may have been, I think it was Southwest Atlanta, he sought out the company of the individuals in the neighborhood that just hung out and looked for a father figure there. He never quite had the personality of someone who was dominant, usually just followed and did whatever they told or asked him to do. His mother at the time was struggling. She was trying to make ends meet. She was trying to do the best for her kids. She knew the environment wasn't the best for them. It just wasn't, it was going to be very difficult for her to try to move out. And honestly, it wasn't until he was arrested on this charge that she says that that's when she made her move to Douglasville, because she realized she just had to get her kids out of that neighborhood. He had been in special education. When I got his records, they reflected that he is reading at the 4th grade level. He cannot do addition or subtraction. I am not sure how he was able to move from the 4th grade to the 9th grade, because everything in his records reflected that he was failing. They did not, whenever they would do a review and a meeting with his mother, they, not to blame the school system for his situation, but his lack of development is a large factor in the poor decision-making that he has made thus far. There was no IEP plan in place, which was surprising to me. There was never any one-on-one meetings with counselors. The most that I had seen in the records was just that teachers would have one-on-one conversations with him to try to get him to attend class more, to try to get him involved. It was very hard. It had to be very basic assignments in order for him to become involved. With that being said, he understands the severity of what occurred and what happened, and he is taking responsibility. He didn't expect that things would escalate the way that they did on that day, but acknowledges that there was a point in which he could have walked away from what was happening and he didn't.
And the evidence is not that Mr. Palmer was driving the van.
Correct.
He was a passenger in it, so he chose to get in it. He didn't drive it.
Correct. And the evidence also, unfortunately, and I'm sure Ms. Hall is working very hard on this, but we're ready to proceed without this. The main surveillance footage has not been turned over to Ms. Hall yet. But what we did have was body camera footage showing of the officer facing the screen, and that showed that at no point did Mr. Palmer have a firearm on him, and police, when they wrote the report, didn't indicate that he had a gun. He does have a history, but it is enter autos, criminal damage. His co-defendant actually had a armed robbery that was reduced to robbery, which I think is indicative of the poor following behavior that my client has. We've talked for a while. I've talked to his family for a while. He's obviously very frightened and very sad that this is the situation that he's in, but he has brought some optimism to it. He discussed that, you know, he'd like to get his GED once he's in prison. He has a child right now who's 5 years old, and he realizes that when he gets out, his child could be 10 or 11 at that point.
You're bigger than you are.
and that he wants to have a good job when he gets out, and that he's going to try to take as many classes that he can to put him in that position while he's in prison. It's an unfortunate situation that he's in. And his family is on the call. I believe his sister, Miss White, are you there? Or perhaps his mother can, there she is, can speak a little just about his background, and that, you know, his history makes him seem like the person that they don't know him to be.
Yeah, just to piggyback off of what you said, he definitely has a following personality. He's never been a leader. We never had we never had someone that was just there to give us the stability that we had. My mom was always at work. She was always trying to do the best that she could just by herself, you know. That was just a struggle in itself. So I don't know, he never had a chance. He never had a chance to be something great. And unfortunately, he hung out with the wrong type of people and put him in the situation that he's in. But yeah, that's I'm sorry. That's pretty much it.
Okay, well, I appreciate that, Ms. White. That helps give an insider's perspective of what Mr. Palmer's been struggling with, and it does sound like because there wasn't the right role model in his life, he ended up spending time with folks who modeled not the right behavior for him.
Exactly.
Okay, thank you.
Thank you.
Ms. Palmer, Lakeisha Palmer, did you want to add anything?
Yes, it's just about the same thing. Like I said, I've always worked, so I was never at home because I had to keep, a roof over our head because it was just me. And just, I kept trying to tell him that the people that he chose wasn't right, but he had to find out on his own. And unfortunately, it's at this point, that I just hate that it has happened to my son.
I understand, and it sounds like things escalated. There were the older cases that were less serious, and yet he stuck with the same crew, and things got a lot worse.
Yeah.
Okay. Well, thank you for plugging in. I know you all had to wait a little bit to hear this and to be heard, but I appreciate. I think it means something to me. Hopefully, it means something to Mr. Palmer that you are still here for him.
Yes.
All right. Thank you.
Thank you.
And Your Honor, we would just ask that Your Honor follow the plea as negotiated. Ms. Hall and I did speak about that 17 SC case, and if Your Honor could revoke the balance of that, I believe it was 1 year, 9 months left. When I looked in the system, Your Honor, on the 15 SC case, I did not see a warrant in the system. And I don't know if that's because he's on parole that a warrant wasn't issued, but I don't know if we could proceed with the revocation on that case.
Okay. Well, let's hear from Ms. Crawford. First, Ms. Crawford, good afternoon. Thanks for hanging in there. Second, so I've heard about 3 priors for Mr. Palmer, a 15 SC, a 17 SC, and an 18 SC. Is that what you have?
Judge, I show where he has 2 open active probation cases. I don't see anywhere where the 17 case is a parole case. I do see a warrant that was an old warrant that I'm trying to pull up. It was from February of 2020, and it was signed by Judge Cox. Let's see what it was for.
It looks like Mr. Palmer pled guilty to 2 cases at once in front of Judge Ellerby in April of 2016. It lists
And
two.
those 2 cases were closed. I think that was, we met once before on these 2 cases, and
Okay.
those 2 cases were supposed to be closed out. So they did go ahead and close those 2 cases, but he does still have 2 active. That 15-140-136 is still active, and the 17-SC-155076. I don't see where it says parole anywhere on that case.
Well, the parole, I see the parole certificate in the 15 SC case. I've not seen one of these before, so I don't know how to read it.
Yeah, I saw them also, but I don't know how to read it.
I know how to manage that one. I have thoughts about how to do that. You don't have additional cases. You've got the ones we've been talking about.
That's correct, just the 15 and 17 case.
Okay. Is there any reason why I could not revoke Mr. Palmer's first offender disposition in the 15 SC case and simply resentence that today, whether he's on parole or probation? Shouldn't I still be able to do that?
Yes, Judge, from my understanding, you should.
Okay. So, Ms. Patel, that's my plan, is to revoke Mr. Palmer's first offender status in the 15 SC case and resentence him. And there won't be any probation with that sentence. It's just going to be time to serve on all the counts. It's like 13 counts or 12 counts of entering auto.
And when you say time to serve, are you sentencing him to 14 years to serve?
No,
Okay.
I'll pronounce it all, but no. It will be less than the amount of time he's serving in this case. So when he's done, when you, Mr. Palmer, are done serving the custodial part of your sentence, in this case, the real serious one, you will have closed out your other 2 cases because those clocks will have run before then. Does that make sense?
Yes, sir.
Okay. All right. What injuries did you get from the accident, the collision of the 2 vans?
My knee, my back, and like my shoulders.
Okay. What happened to your knee?
It got cut open.
Okay. So it needed stitches?
I really don't remember because I was out, but I know I was in medical with it wrapped then.
It's got a big scar?
Yes, sir.
Okay. And your back and your shoulder, did that need surgery or just it still hurts?
It still hurts.
Okay. Did you get a concussion?
Not that I remember.
Okay.
I believe there was some type of brain trauma or injury because he could not remember much of anything in the first 2 weeks of me trying to even speak to him about the situation.
You have 1 kid?
Yes, sir.
Boy or girl?
Boy.
What's his name?
Jeremiah.
And he's 5?
Yes, sir.
Does he live with his mother?
He lived with his grandmother.
His grandmother?
Yes, sir.
Where's his mother?
I know he be with her a lot, but right now at this moment, I don't know, sir.
Okay. You understand that you may be asked to testify if Mr. O'Neill chooses to go to trial?
Yes, sir.
And you're prepared to do that?
Yes, sir.
Okay. So, Mr. Palmer, I find there is a factual basis for your plea in this case. Things got real serious real quickly, whether you intended for them or not. It doesn't sound like you were the main actor, but you were a participant in it. And I guess we're lucky that it's your knee and your shoulder and your back and not you went through the windshield and died. We're really lucky that no one in that other van got killed and that no one got shot. You and Mr. O'Neill had moved things to a different level from these older cases where it sounds like maybe people were just breaking into unoccupied cars. I also find that your plea is knowing and voluntary. Knowing means that you've understood the things we talked about, and if you didn't, you and Ms. Patel talked about them. Is that a fair statement?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
A voluntary plea just means that no one's forcing you to do this. This isn't a happy moment. I don't think you're excited about it, but you're entering a plea because you think that's the right way to move forward. Is that true?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that for the probation part of your sentence, If you have a little problem on probation, maybe you miss a meeting or something, you and probation will work that out. If you get arrested again, new charges, that comes back to me and we'll work that out. It doesn't sound like, Ms. Hall, there's any restitution. The vehicle, I mean, it sounds like 2 vans were totaled, but I haven't heard you say anything about restitution.
Yes, Your Honor. I didn't because there is a restitution, but I was going to assign that to the co-defendant because that did come from the tolling of those vans and he was driving. I put on the record though, it's $7,589.45 for the incident, but I was going to attach it to the other co-defendant.
Who was driving the van?
Yes, Your Honor.
Okay.
And that is why I know apprised anything that dealt with driving the van for this co-defendant and then the gun charges.
And the gun. That makes sense. I got that. Okay. Mr. Palmer, I am going to invoke the statutory provision at 1710 6.1E. That's a lot of numbers and letters. But what that means is if the prosecutor agrees with your lawyer that I should think about going below the mandatory minimum, which is 10 years without parole, I can think about it. And I am comfortable going a little bit below it. It sounds like, as between you and your co-defendant, you were the less involved, but you were still involved. And as I've already talked about, folks could have died as a result of this. You could have gotten shot. You know, O'Neill pulls out a gun and the guy who owns the car pulls out a bigger gun and shoots you. That doesn't help anyone. So this had gotten to a point where you need to do something different. This isn't going to work out as a way to go forward. That said, I appreciate that life has been pretty complicated for you and that you haven't enjoyed lots of the opportunities that other young men did, having a dad around, finding school not hard to do, et cetera. You got a little boy who needs you to be present in his life someday. You've got family that cares about you. They dialed in and they're still here for you. So you need to make them proud by turning a corner. And it sounds like you're going to try to do some of that while you're in custody. I am going to sentence you on all 5 counts, 1 through 5, the ones that remain, to 12 years to serve 7 years with the balance on probation. So it's 1 more year of probation than you had negotiated, and it's 1 more year in custody. I went up a little bit because I think this is serious enough, and you got 5 years to serve already from Judge Ellerby for the 12 entering autos. And I don't think that going up just 1 year reflects the seriousness of what you got involved with. And I appreciate what your sister said and your mom said, that you tended to follow these guys, but you still were with them. And you knew pretty well back in 2015 what these guys were up to. And there you were again with Mr. O'Neill 4 years later. And like we've all talked about, it got a whole lot more serious. And that was after you did some time for hanging out with the guy. So obviously you need to stay away from him. He doesn't bring good things to you or your family. My proposal, Ms. Patel, is to revoke the balance on 17 SC and run it concurrently. It's less than 2 years. And in the 15 SC case is to revoke first offender status and to resentence on all 12 counts, 5 years to serve, and they all run concurrently. And it doesn't matter how they do the math. I think Mr. Palmer would get some credit on those 5 because he has done some time, in particular with the parole revocation. But even if they gave Mr. Palmer, well, that's not quite right because he's already served 18 months. So we'll just need to make sure that with that revocation, he gets credit from October 12th, 2019. And then that sentence, the new sentence he's getting on the 15 SC case will not extend beyond the term he'll need to serve as a result of this case. So I don't know if you were prepared to deal with the 15 SC case. If you want to confer with Mr. Palmer briefly and let me know you're willing to go forward with that. Otherwise, he's going to have to come back at some point to deal with it.
If I could just have a moment to
Sure.
confer with Mr. Palmer.
Ms. Patel?
Your Honor, my client would like to accept Your Honor's sentence and is prepared to move forward with the 15 SC revocation.
Okay. So, Mr. Palmer, you understand what your sentence will be in this case, the 19 SC case, the carjacking matter. In the case of 17 SC 155076, given this new conviction, I'll revoke the balance in that case. That's the one where it's less than 2 years remaining. Yeah. And then in 15 SC 140136, I'm going to revoke your first offender status and resentence you. And your sentences to each of the 12 counts will be 5 years to serve. Those will all run concurrently with each other, meaning at the same time. And you will get credit from October 13th, 2019. That's when you went into custody in that case. And all these things are going to run together. So you can do the math. You've been in for about 18 months. So you've got 5.5 years remaining. I don't believe you're parole eligible because it's an armed robbery count. But I don't know how it works when the judge invokes that subsection E where we get below the 10 years. Ms. Patel can talk to you about that. The only other question I've got, Mr. Palmer, normally you'd sign your indictment indicating that you're pleading guilty, but we're not passing papers around because of the pandemic. Do you authorize me to sign the indictment for you?
Yes, sir.
And Ms. Patel, may I sign for you?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Ms. Hall, anything else from the state?
Nothing further from the state, Your Honor.
Ms. Patel, anything on behalf of Mr. Palmer?
Nothing further, Your Honor.
Mr. Palmer, I forgot to ask you if there was anything you wanted to say about the case. Anything you want to add? You don't have to say anything at all. I should have asked you earlier, but I didn't mean to prevent you from doing that.
I just want to thank you for hearing me out and giving me another chance, sir.
Okay. Well, be there for your mom and your sister, and most importantly for Jeremiah when you get out.
Yes, sir.
Okay. Ms. Crawford, do you need to get information from Mr. Palmer, or the fact that he's going into custody for a while, that'll be sorted out when he gets released?
Yes, sir. It'll be sorted out at a later date.
Okay. I think that's it. Thank you, everyone. Thank you, Ms. Nelson, for extending this. And we will see folks at drug court tomorrow. So I don't think I'll see any of you tomorrow. We may have some things on Thursday.
You're welcome.
Right. Thanks, Ms. Rivers.
Okay, Judge, have a nice evening.
You too.
Ms. Nelson, I have a question for you. One.
Yes, ma'am.
Just a moment. Oh, for Ms. Nelson, I'm sorry.
Oh, for Ms. Nelson. Okay.
Yes, ma'am.
Thank you, deputies. Long
when
day.
you do the revoke the first offender, can you send me the new sentence sheet?
I will.
The new disposition?
Yes, I will.
Okay. All right. Thank you.
Uh-huh.